I'm going to tell you about the strangest legal fight I've ever been dragged into. And it started with a woman stepping out of a black luxury SUV, pointing at my front gate like she already owned it. She looked me dead in the eye and calmly informed me that I had exactly 14 days to surrender access to several hundred acres of my land before her homeowners association sued me into compliance. The only problem was, every word she believed was true had been built on a mistake that had been hiding inside county records for almost 30 years. My name is Ethan Walker. I'm 54 years old, and for most of my life I've worked with land. Not the glamorous kind you see in glossy real estate magazines, but hardwood forests, creek bottoms, cattle pastures, places where fences matter more than fences on paper, and where one old survey marker can decide whether a family spends Thanksgiving together or in court. I guess growing up in eastern Kentucky teaches you that land isn't just dirt. It's memory. It's history. Sometimes it's the only thing people have left to pass on. That Tuesday morning started like hundreds before it. I was replacing a broken section of fence near the entrance to my property while a pot of coffee sat warming on the stove inside. October had settled into the hills, and the maple trees had started turning that deep orange that only lasts a week or two before the first hard wind strips everything bare. I remember thinking it was too quiet for the middle of the week when I heard tires crunching over the gravel road. The SUV stopped 20 feet from me. The driver didn't hesitate. She climbed out wearing polished boots, a tailored navy blazer, sunglasses even though the sun was hiding behind clouds, and she carried one of those expensive leather folders people seem to hold when they're convinced paperwork automatically makes them right. "You must be Mr. Walker." "I am. I'm Rebecca Langford, president of the Cedar Bluff Estates Homeowners Association." She smiled, but it wasn't a friendly smile. It was the kind people practice before walking into difficult meetings. "I'm here to notify you that you're currently violating the association's recorded access covenant. You'll need to unlock the north pasture entrance within 14 days. If not, legal action will begin immediately." She delivered every sentence without raising her voice. No hesitation, no uncertainty, like she'd rehearsed it on the drive over. I leaned on the fence post and looked past her toward the hills behind the subdivision sitting nearly a mile away. "I'm sorry," I finally said. "What pasture?" "The north grazing pasture. I don't own any property inside Cedar Bluff." She opened her folder, pulled out several papers, and held one toward me. "Actually," she replied, "your land falls under the original development agreement." I glanced at the first page, then the second, then back at her. For a second I honestly wondered if she'd accidentally driven to the wrong address. "I think you've made a mistake." She folded her arms. "No, Mr. Walker. We verified everything before coming." That sentence stuck with me. We verified everything. Funny thing about people who announce they've verified everything. They usually haven't. I handed the papers back. "I appreciate you making the drive." She frowned slightly, probably expecting an argument. Instead, I smiled. "I'll read these. 14 days. I heard you." She climbed back into the SUV, backed down my gravel lane without another word, and disappeared around the bend. I stood there for another minute listening to the leaves move through the trees. Not angry, not worried, just curious, because something about the entire conversation felt wrong. Not emotionally wrong, professionally wrong. Like watching someone confidently explain directions while holding the map upside down. Inside my kitchen, I poured myself another cup of coffee and opened the bottom drawer beside the refrigerator. Most people keep junk in that drawer. Rubber bands, old batteries, takeout menus. Mine held deeds, survey maps, closing documents, title insurance. Every property record I'd accumulated over 25 years buying timberland across Appalachia. Some people collect baseball cards, I collected paperwork. My father used to joke that if our house ever caught fire, I'd rescue county records before family photographs. Truth was, he wasn't entirely wrong. Dad had spent 40 years as a surveyor. His favorite saying was simple: people lie. Fences move. Memories fade. County records don't. He repeated it so often that eventually it stopped sounding like advice and started sounding like gravity, something that simply existed whether you liked it or not. I found the deed for Cedar Hollow Preserve exactly where I'd left it. 3,200 acres, purchased 7 months earlier, every signature notarized, every page recorded with the county clock the same afternoon we closed. I spread the documents across my kitchen table beside Rebecca's demand letter. Her packet claimed my property was subject to an HOA covenant recorded in 1996. Mine showed the legal description of every acre I'd purchased. I read both twice, then a third time. The more I compared them, the stranger everything became, because the covenant she relied on never actually mentioned my property. Not once. It described architectural guidelines, mailbox standards, road maintenance, community dues. Nothing about my valley, nothing about my pastures, nothing about me. Still, experience had taught me something important. Never assume someone is completely wrong until you understand exactly why they believe they're right. That's usually where the real story begins. I called the only person I trusted with questions like this. Laura Bennett, property attorney, 34 years practicing land law. She'd handled 4 closings for me over the years and knew county records better than some county clerks. She answered on the second ring. "Ethan, you busy? Depends. I've got an HOA president trying to take my pasture." Silence. Then she laughed. "I'm serious." "I know." Another pause. "Bring everything." Her office occupied the second floor above an old hardware store downtown. The wooden staircase creaked exactly the same way it had 10 years earlier. Laura hadn't changed much either. Same reading glasses balanced halfway down her nose. Same stacks of organized folders. Same coffee mug that permanently smelled like black coffee no matter how many times it had been washed. She read Rebecca's letter without interrupting. Then she flipped through the attached covenant. Then she picked up my deed. 5 minutes passed, maybe 10. Finally, she looked over her glasses. "Ethan." "Yeah." Either someone misunderstood a legal document. She tapped the covenant with one finger. Or someone never actually read it. "You think they're bluffing?" "I don't think." She closed the folder. "I verify." That was Laura, never conclusions, only evidence. She opened her calendar. "I'm requesting every recorded instrument tied to both properties. Original patents, easements, subdivision filings, title transfers, everything." "How long, if the archives cooperate?" She leaned back. 2 weeks. I smiled. "I've waited longer for deer season." She laughed. "I had a feeling you'd say that." Walking back to my truck that afternoon, I looked toward the ridge where Cedar Bluff Estates sat hidden behind rows of expensive houses with identical stone mailboxes and perfectly trimmed lawns. From where I stood, they looked peaceful, ordinary, like nothing unusual had ever happened there. But somewhere inside those county records, buried beneath decades of paperwork and forgotten signatures, was a reason an HOA president had driven 40 miles to threaten the wrong landowner with complete confidence. And I had a feeling that whatever Laura was about to uncover was going to be much bigger than a disagreement over a locked pasture gate. Laura called 19 days later, not 14 like she'd hoped. 19. Apparently half the older county records still lived in dusty storage boxes because nobody had ever bothered digitizing them, and the clerk's office had spent nearly a week pulling oversized survey books from a basement archive that smelled, according to Laura, like wet cardboard and forgotten lawsuits. I drove into town the same afternoon. When I walked into her office, the first thing I noticed wasn't Laura. It was the stack of banker boxes sitting beside her desk. 3 of them, each packed with copied deeds, plats, easement filings, mortgages, foreclosure notices, handwritten surveys, and enough legal history to make anyone's eyes glaze over, except mine. Laura looked tired, which usually meant she'd found something interesting. "You hungry?" she asked. "Should I be? Depends how much you enjoy legal archaeology." I pulled up a chair. She slid the first binder toward me. "Let's take a walk through 30 years of bad decisions." I laughed. "I already like where this is going." She pointed to the earliest document, the original farm. In 1988, the entire valley had belonged to one family. Nearly 4,000 acres, mostly timber, some cattle pasture, nothing unusual. Then came the first sale. A regional development company purchased roughly 700 acres along the Western Ridge. That eventually became Cedar Bluff Estates. Everything looked normal. Every transfer made sense. Every boundary matched. Then we reached 1996. Rebecca's famous HOA covenant. Laura tapped it with her pen. "This governs the subdivision." I noticed. "It governs only the subdivision." "I noticed that too," she smiled. "I know. So why does their president think she owns my pasture?" Laura reached into the second binder. "Because of this." She laid another document in front of me, recorded in 2000, title Declaration of Recreational Access Easement. I leaned closer. Now that was interesting. According to the document, homeowners inside Cedar Bluff Estates supposedly possessed permanent access rights across what was described as the northern grazing fields of my property. I looked up. So there really was an easement. Laura didn't answer. She simply watched me keep reading. Something about her expression told me I hadn't reached the important part yet. After another minute, I set the pages down. "It looks legitimate." "It does. But," she smiled again. "But read the legal description." I frowned. Survey numbers had never intimidated me. Growing up with a surveyor for a father meant legal descriptions almost felt like another language I'd learned as a kid. Township, section, parcel, boundary calls, reference markers. I followed each line carefully. North, east, creek, corner monument, parcel identification number. Then I stopped. "Well," Laura folded her arms. "You found it." I looked back at the parcel number. Then at the county geese map she'd printed. Then back again. "That's impossible." "Exactly. The easement wasn't describing my pasture. It wasn't even describing my valley. The parcel number belonged to a 12-acre community green space sitting entirely inside Cedar Bluff Estates. A walking trail, a picnic area, some playground equipment, nowhere close to my ranch. I leaned back. "So somebody copied the wrong parcel." Laura nodded. "Looks that way." I laughed once. Not because it was funny. 'Cause it was unbelievable. Rebecca threatened a lawsuit, using an easement that legally points to her own neighborhood park. Pretty much. For a few seconds, neither of us spoke. Then Laura said something that completely changed the story. "That's only the first problem." Of course it was. She reached into the last binder. "You remember the developer, the one who built Cedar Bluff?" "Yes." She pulled out mortgage filings, bank records, foreclosure notices. In 1996. She traced one line with her finger. "The developer borrowed several $1 million using the remaining farmland as collateral." I nodded. "Okay." 4 years later, she tapped the easement. "They recorded this access agreement. So they never got permission from the lender." I stared at her. "You mean?" "The bank held superior interest." "Meaning?" "They couldn't legally grant permanent access over collateral without lender approval." I whistled softly. "And they never asked?" "No." "They never signed?" "No." "And then," Laura slid over another document, foreclosure judgment. "The bank foreclosed." I read the first page, then the second. Then the order itself, every junior interest extinguished, every subordinate claim erased, including the recreational easement. I looked up slowly. "So even if," she nodded, Even if the parcel description had been correct, the foreclosure wiped it out. 20 years ago. I honestly didn't know whether to laugh or feel sorry for Rebecca. She'd driven all the way to my house completely convinced she was defending her neighborhood's rights. Instead, she'd built her entire argument on a legal document that had died before some of her current neighbors had even moved into the subdivision. Laura folded her hands. If this ends today, it should. It won't. Why? Because people rarely enjoy discovering they've been wrong. I should have listened more carefully to that sentence. 3 days later, a certified envelope arrived. Not from Rebecca, from a law firm in Lexington. 4 attorneys listed on the letterhead. Expensive paper, expensive language, expensive confidence. I sat at my kitchen table reading every page while coffee slowly went cold beside me. Laura was right. They weren't backing down. They had simply changed the argument. Instead of claiming a recorded easement, they now claimed a prescriptive easement. Basically, forget the paperwork, forget the recording errors, forget the foreclosure. Their position was simple. Homeowners had crossed my pasture openly for decades, long enough to earn permanent legal rights through continuous use. It was smarter, much smarter, and honestly, for the first time since this whole thing started, I felt something besides curiosity. Concern, not panic, just respect. Because unlike Rebecca's original claim, this one wasn't ridiculous. Laura came over that evening. She spread the letter across my dining room table. "This," she said quietly, "is where the real fight starts. What do we need? Evidence. What kind? History." She looked out the kitchen window toward the tree line. "If people really cross that pasture continuously for 15 years, we lose, potentially. And if they didn't, we prove it." "How?" she smiled. "The old-fashioned way." The next morning we started knocking on doors. Not dramatically. Not accusing anyone, just asking questions. Old farmers, former employees, retired deputies, mail carriers, anyone who had lived around Cedar Hollow long enough to remember what happened before luxury homes replaced cornfields. Most remembered little. A few remembered enough. Then we met Harold Benson, 71 years old, retired cattle farmer, owned the neighboring property since 1983. His handshake felt like grabbing a shovel handle, strong, dry, honest. When Laura asked whether subdivision residents had ever crossed my pasture, he scratched his chin. "Used to," my stomach tightened. "When? Oh, late 90s maybe. Regularly, couple horseback riders." He looked toward the ridge. "Families too." Laura stayed calm. "And after that," Harold laughed. "Oh, that didn't last." "Why not?" "The old owner got tired of finding gates open." He pointed toward my northern fence line. "They chained the entrance shut." "When?" He looked up at the sky for a long moment. "I'd guess around 2000. You sure?" "I helped hang the chain." Laura and I exchanged a glance. Neither of us spoke. Harold continued. "Meanest old rancher I ever knew." "What happened after the chain?" "Nothing. No one crossed. Not unless they planned on cutting fences." He chuckled. "Folks quit trying pretty quick." Laura asked one final question. "Would you swear to that under oath?" Harold looked almost offended. "Ma'am," he smiled. "I've been telling the truth longer than most lawyers have been alive." Driving home that afternoon, neither Laura nor I said much. The sun was dropping behind the hills. Long shadows stretched across the pasture Rebecca wanted access to. Somewhere beyond those trees, people inside Cedar Bluff Estates probably still believed those fields belonged, at least in part, to them. But one old farmer had just handed us the first crack in their entire case. If Harold's memory proved accurate, someone had locked that gate decades ago. And if the gate had truly stayed locked, then the clock required for a prescriptive easement had never finished running, which meant the next phase of this fight wasn't going to depend on opinions anymore. It was going to depend on something far more dangerous in a courtroom: facts. The next 6 weeks felt less like preparing for a lawsuit and more like putting together a puzzle someone else had scattered across 3 decades. Laura never rushed. She believed good cases were built the same way old bonds were built, one solid beam at a time, because if the foundation was right, the rest would hold on its own. We hired a licensed surveyor named Daniel Pierce, a quiet man who carried himself with the confidence of someone who trusted measurements more than opinions. He spent 3 full days walking every boundary of Cedar Hollow Preserve. I tagged along for most of it, partly because I wanted to understand every inch of my own land, partly because I needed something to do besides imagining worst-case scenarios. Daniel found every original survey monument, every iron pin, every stone marker buried beneath years of leaves. By the time he finished, his certified plat confirmed exactly what my deed had always shown. The subdivision never touched my property. Not by an inch, but Daniel found something else that none of us expected to become important. Near the northern entrance, hidden behind years of brush, sat an old steel chain wrapped around 2 cedar posts. The lock had rusted so badly that the cedar tree had literally begun growing around it. Daniel photographed everything. "This gate hasn't opened in a very long time," he said quietly. Laura smiled without saying a word. 2 days later, Harold signed a sworn affidavit confirming he had personally helped install that chain sometime around the summer of 2000 after repeated trespassing complaints. Then something even better happened. Laura tracked down Margaret Collins, the daughter of the family that had owned Cedar Hollow before I bought it. Margaret lived 2 counties away now, but she still kept every file her father had ever saved. We met her in a small office beside her accounting business. She carried in a faded cardboard box that looked older than I was. "Dad never threw paperwork away," she said with a laugh. "Mom hated it." Inside were old receipts, fence repair invoices, photographs, handwritten notes, and one certified letter dated August 18, 2000. The letter had been sent to the original subdivision developer. It stated in plain English that all access across the northern pasture was unauthorized, that the entrance had been locked, and that anyone entering the property afterward would be considered trespassing. Better yet, the certified mail receipt was still stapled to the back. Laura looked at me and quietly whispered, "That's the moment their clock stopped." From that point forward, our case almost built itself. Every document told the same story. Every witness supported the last. Every survey matched every deed. We weren't creating evidence. We were simply uncovering what had always been there. The hearing finally arrived in early March. I'd been inside courtrooms before, but never as the center of the dispute. The courtroom wasn't glamorous. No dramatic television lighting. No packed audience. Just old wooden benches, fluorescent lights, and the smell of aging paper mixed with coffee. Across the aisle sat Rebecca Langford. She looked different than the woman who had stood at my gate months earlier, still dressed professionally, still holding that leather portfolio. But the certainty I'd seen that first morning had disappeared. Beside her sat 2 attorneys from Lexington, expensive suits, expensive watches, thick legal pads. They nodded politely as we took our seats. Judge Samuel Hayes entered exactly at 9 o'clock. He wasted almost no time. "Counsel," he said, looking toward the HOA attorneys, "identify the legal instrument granting your clients access to the defendant's property." One attorney stood confidently. "Your Honor, the 2000 Declaration of Recreational Easement." Judge Hayes adjusted his glasses. "The document already admitted into evidence." "Yes, Your Honor. Please identify the parcel described in its legal description." The attorney read the parcel number aloud. Judge Hayes turned toward the large survey exhibit Daniel had prepared. He studied it for several seconds before looking back at counsel. That parcel is located inside your client's subdivision park, is it not? Silence. It lasted only 3 or 4 seconds, but in a courtroom it felt much longer. Finally, the attorney answered, "Yes, Your Honor. So the recorded easement does not describe Mr. Walker's property." "Not specifically." The judge didn't react. He simply made a note and looked toward Laura. "Counsel," Laura stood calmly. "Your Honor, even if the legal description had been accurate, the document was extinguished by foreclosure in 2004. We have provided the recorded judgment, the mortgage priority, and certified copies of every relevant filing." Judge Hayes nodded. "I've reviewed them." One of the HOA attorneys immediately shifted strategies. "Your Honor, our primary position is prescriptive easement based upon decades of continuous public use." Laura waited until he finished. Then she approached the witness stand carrying only one folder. "Your Honor, continuous use requires continuity." She handed the clerk Harold's affidavit, then Margaret's certified letter, then Daniel's survey photographs. Finally, she displayed the enlarged photograph of the rusted chain growing into the cedar tree. The prior owners objected in writing. They physically secured the entrance. The objection was delivered by certified mail. The gate remained locked. Continuous use ended before the statutory period could ever mature. Judge Hayes leaned back in his chair. "Counsel," he asked the HOA attorney, "do you possess any sworn testimony establishing uninterrupted use after August of 2000? The attorney hesitated. "No, Your Honor." "Any photographs?" "No." "Any maintenance records?" "No." "Any witnesses contradicting these affidavits?" "No." The courtroom became very quiet. Rebecca slowly lowered her eyes toward the table. "I honestly didn't feel satisfaction. Mostly I felt relief, because none of this should have happened in the first place." Judge Hayes announced he would issue a written ruling within 2 weeks. 9 days later, Laura called. I could hear the smile in her voice before she even spoke. "Congratulations. That good. Come read it yourself." The opinion stretched 11 pages. The language wasn't emotional. Judges rarely are. But the conclusion couldn't have been clearer. The court found that the recorded easement failed because it described the wrong parcel. Independently, any possible prescriptive claim had been interrupted by written objection and physical closure of the entrance decades earlier. Cedar Bluff Estates possessed no legal right to enter Cedar Hollow Preserve. The HOA's claims were dismissed with prejudice. They were ordered to withdraw every recorded claim against my property and reimburse more than $20,000 in legal fees. I read the decision twice before setting it back on Laura's desk. She looked at me and smiled. "Worth keeping county records," I laughed. "Dad would have enjoyed this." A month later, I walked the northern fence again. Spring had finally arrived. Dogwoods were blooming along the creek. Birds filled the woods with the kind of noise that somehow still feels peaceful. And that old cedar post stood exactly where Harold had helped set the chain nearly 25 years earlier. I rested my hand against the rough bark and realized something. Winning wasn't the part that stayed with me. What stayed with me was how easily confidence can masquerade as authority. Rebecca honestly believed she was protecting her community. Her attorneys believed they could repair decades of bad paperwork with aggressive arguments, but none of that changed reality. Reality had been sitting quietly inside county archives all along, waiting for someone willing to read every page instead of assuming they already knew the answer. I never hated Rebecca. If anything, I hope she learned the same lesson I did. Before you threaten someone, before you accuse someone, before you convince yourself you're standing on solid ground, make absolutely sure you're not standing on someone else's mistake. Because once the facts finally come to light, confidence disappears a whole lot faster than the truth. So now I'd really like to hear from you. If you were in my position, would you have accepted an apology and moved on? Or would you have pursued additional legal action against the HOA after everything they put you through? Do you think Rebecca was simply misled by bad records, or do you think she let power cloud her judgment? Share your thoughts in the comments, because stories like this always spark interesting debates. And if you enjoy real property disputes, courtroom victories, and true-to-life legal drama, don't forget to subscribe, because the next story might be even more unbelievable than this one.